I may, I will first of all respond to the two queries that my Lord Justice Richards raised previously. If I may show you a letter and an application notice in respect of the G&G's application, then I'll move on to the second, the conditions appeal. First point, my Lord, you asked me, paragraph 53 of the defence, it is denied there's any other breach of fiduciary view of alleged understanding for the reasons set out above, and you asked if there's anything particular I should draw to your attention. I just draw to your attention, if I may, page 365, paragraph 27 and 28. The petitions represent an opportunistic attempt to cherry-pick with hindsight certain payments from a large number of payments made between the various companies on the basis described above, with a view to portraying the actions of Mr Gourgey and Mr Hodges self-serving. In fact, they were made in accordance with practice of which Mr Griffith knew and consented. Mr Griffith operated the affairs of the company on exactly the same basis, and so on. And paragraph 28, in the period between 1996 and his resignation in 2010, Mr Griffith never raised any complaint about all of this. And so those are points just to draw to your attention on that. Secondly, my Lord, you asked us by reference to, I think, paragraphs 3 to 5 to 13 of the judgment of Mr. Justice Simon. In general terms, we consider this it's a approximately accurate summary. You will note that there is no reference there to the involvement of the sons in the misconduct in respect of G&G. For the most part, all of these allegations, as summarised, were focused on Mr Gourgey, as indeed everyone's attention seemed to be until more recently. Thirdly, you may recall that the backdrop to the application being made before Sir Nicholas Warren was that Mr Narak, or more accurately his widow, applied to strike out the claim for relief against him. That was acceded to by Judge Pelling in November 2017. It was after that application, and in the build-up to the hearing that was going to take up in April, where the primary issue at the hearing in April was that the petitioner said they were entitled to an immediate share purchase order because the defences had been struck out, and they wanted a substantial interim payment on account, and they saw this as effectively a final hearing. That's where we were at. That was a backdrop to this application being made. And if I can just briefly take you to supplemental bundle 20, divided 24.
Where is this leading to?
Just to explain what we were trying to get the petitioner to do in the build-up to the hearing of our application.
Where does this connect with any ground of appeal?
Well, it connects to the backdrop being that we said you have not pleaded anything in your petition. What you pleaded in your particular claim is vague and inadequate, and you either amend to cure the deficiencies in your pleading, or will apply to strike out. And indeed, the application notice, and that's apparent from the letter, which I wanted to briefly take you to, but
if you're saying it's apparent from some document, a strikeout application itself just shows the document and the strikeout application.
Well, I could take you to the strikeout application. It summarises the position, yes. And if I can just briefly take you to that, it's at page divider 8 of the supplemental bundle. Page 28.
Divider 8.
Divider 8 of the supplemental bundle. Divider 8, page 28. This was the application which came before the judge. And you'll see it's either be struck out or within 28 days the petitioner applied to amend so as properly to particularize the claim that the first and or second respondent has or have been concerned in conducting the affairs of the company in an unfairly prejudicial manner. Failing which references be struck out. That was the alternative. But because the point being, there was no wrap-up allegation. There was an allegation of support of the sons, but there was no indication as to why that should lead. That constituted conduct to affairs of a company by the sons, such that a share purchase order or indeed any remedy should be ordered against them. And so moving on, you'll see page 30. It says, paragraph 12, no allegations are made against Neil or Charles in the petition. And paragraph 17, and it points out, fails to explain what, 12.1, fails to explain what is meant by expression with the support of the sons. And at paragraph 17, they relied upon the fact there's no allegations in the petition. The particular claim failed to set out, paragraph 17.2, how either of them is alleged to have been concerned either directly or indirectly in conducting its affairs in an unfairly prejudicial manner. The nebulous and half-baked side allegation at paragraph 36, Mr Gourgey caused various payments that must be paid out with the support of the sons, whatever that means, is wholly unparticularised and plainly insufficient to constitute a properly pleaded allegation that either Neil or Charles was concerned in conducting its affairs in an unfairly prejudicial manner. And then they go on to say, 18, in circumstances, there's no realistic prospect of the court making an order on this basis. The alternative relief at 19, and if it's not minded to strike out, it's asked to order that he apply for permission to amend within 28 days to properly particularise the claim, failing which the claim is struck out. Such an application to amend is manifestly necessary in the light of the absence of any proper allegation that either Neil or Charles was concerned in conducting its affairs in an unfairly prejudicial manner. So where we were coming from was trying to get some order into this case. They were going for an immediate share purchase order without a need for a trial. We said, no, there needs to be a trial. That it's a statutory jurisdiction. The court can't be satisfied sufficient to make a share purchase order on the basis of a defence having been struck out. It has to be satisfied the petition is well founded, and that's what was dealt with by Sir Nicholas Warren in his first judgment. He agreed. He said you can't get judgment by default. And so it was effectively a case management conference going forward to see what was the consequence of where we were at that time. Mr Narek had his claim against him struck out. Trueshow was applying to have a claim against it struck out because there was no pleaded allegation against it in the Bankside petition. Simultaneously with that, Neil and Charles applied either to strike out the G&G petition or to require Mr Griffith to properly set out his case on this. Mr Griffith decided, no, everything's perfectly properly pleaded, I'm not going to amend. It's only when the first judgment was being handed down that he then said, well, actually, I do want to amend, here's my draft amended pleading. And in Vice, it's important to see the backdrop to this. It's not a situation of the respondents trying to cause difficulties or take some sort of advantage of procedural gains. It was a situation where it was difficult to understand, and I submit it still remains difficult to understand, what is the case they need to meet at trial. There will need to be a trial, albeit the role that, depending on whether what role they can take going forward or whether what defence they're going to put forward will need to be considered. But this was a case management.
I think it seems to me, if I may say so, that all this might go to questions of costs, but I don't see it right at the moment might deal with the issues that have to deal with on the appeal about whether or not there should have been a strikeout and so on. So, I mean, I understand the background, the justification, and I'm not saying you're wrong about any of that. I can see what's in the application to strike out. I can see all of that, but I don't think it really assists in us determining the substance of the appeal.
My lord, it's important that I submitted for backdrop. I don't want to spend more time on it.
I understand. I understand.
And to show that there was a proper point here, which is the support of the sons was just nebulous. Now, moving on to the conditions appeal, you may have been troubled by a short note that we provided yesterday morning. The purpose of that was simply to try and identify what we considered is maybe the relevant CPR provision.
Can I just get sorry, I'm so sorry, Mr. Gourgey. Let me just get the grounds of appeal up again, just to see what we're addressing now. So we've now dealt with 1, 2, and 4, and now you're addressing 3. Is that right? So this is, I understand. So I think the Mr. Parker's position is that he doesn't need 3 if we hold that the judge should not have struck out.
I think his position would be that he elected to amend on terms that he had to replead. They had to allow us back in. It's his position also that he wants to go back on the amendments if it's found that the G&G petition was not strikeable, then he would all the amendment arguments about amending a pleading should not, and the election he took should be undone.
Well, I think we have to slightly reconstruct. My current understanding, no doubt Mr. Parker will correct me if I'm wrong, is this: that if the only significant error was that the petition did not contain what was in the particular points of claim, and had it contained those particulars, then no further amendment was necessary in the absence of a request for particulars. Then he doesn't need to worry about 3, because all that's happening there is that what was already in the points of claim carries over into the petition, and the judge should not have held that gave rise to any need for pleading to the whole of effectively all the claims. That's I think his position, and it's only if he's not right on that point that this point comes in. Is that right, Mr. Griffith? That's correct.
On the basis that the amendments for which he sought and obtained permission went well beyond correcting the petition with the points of claim, but actually made substantive additions.
He doesn't need to rely on them. That's the hypothesis.
So that those wouldn't exist
Exactly.
The pleading would be as per the points of claim, but with additional words added to the petition.
So the position is that if this point really only arises if he is wrong and you are right about ground 2.
Yes. It arises in any event in respect of Bankside, the 8 shares.
Well, Bankside is number 5.
Ground 5, yes.
So
we provided a note on yesterday morning because we were trying to consider what would be the appropriate CPR provision from which to view what the judge did. There wasn't any analysis at first instance.
So I think he would say, so this right, and I ought to have completed what Mr. Parker's position is, and so Mr. Parker's position would be if he was wrong on 2, and the further amendments he's now made or proffered were necessary, all the judge should have done was to make the amendments conditional on your side pleading to those amendments.
Yes.
Not to the whole thing. That's
i.e. the amendments.
amendments necessary to sustain the petition and the points of particulars of claim.
Which included some additions to the points of claim as well as amendments to additions to the petition. Yes.
Correct.
Yes.
So I think that therefore that is the narrow issue on this point.
Right. Well, I just want to, since it's a common issue for grounds 3 and 5, what is the jurisdiction in which we're dealing? We provided this note simply to identify CPR Rule 3.13 as the potential likely CPR provision which applies. That wasn't a matter which was ever analysed below. No one looked at it in terms of, well, which CPR provision are we talking about?
So that would give the power, you say, I don't know if that's been denied by Mr. Parker, that doesn't give the court jurisdiction. I thought the court had inherent jurisdiction anyway to do this. The only question you would say is, did the judge make an error of principle in exercising his discretion, or acting outside the bounds of a proper exercise of discretion, in the sense that no judge properly apprising themselves of the position would have reached that conclusion? That's the issue.
Yes. So we simply thought if the Court of Appeal is going to consider this question, it may be useful to look at it by reference to the relevant CPR provision, which considers the imposition of conditions, and there is in the note we refer to. We say that's probably a better fit than CPR 17.3.1 on looking at it closely in the build-up to the appeal, and we identify the two cases which are referred to in the White Book on this provision. We cited in the note what we regard as the relevant provisions. I don't know whether it might be not necessary for me to sort of spell it out, other than that the condition can be imposed as a price for the court granting the relief sought. Yes. So, for example, in other words, the court hearing an amendment application has a power to do what it considers appropriate as to what condition it might apply or not apply, and it seemed to us that simply that was the appropriate lever for the court to consider this application as a backdrop to. Now, on the and the point being, there's no limit on the court being able to say, well, the court can only allow someone to plead to the amendments. The court has a wider power, and that's simply the point. In case it was going to put that somehow the court was constrained in some way, and we'd say no. Whether it's under the inherent jurisdiction or under this rule, the court has a power which goes back to the Sneed case, which we cite in our skeleton argument, of the court making an order which he thought would meet all the equities of the case. So moving on then to what we say is the exercise of discretion by Sir Nicholas Warren. He made clear, and if we deal, the Lordship would prefer I deal with the G&G.
I think so. I think it's easier if you just make your submission by reference to particular grounds of appeal.
Yes.
So we're dealing with G&G.
So in that case,
you want to take us to what he actually said?
Yes. It's paragraph. You go to bundle 1, page 93.
Yes. This is an argument.
Did you say 93? 193?
193, sorry.
193.
Oh, sorry. I'm grateful. I had a missed. I had a typo there. And that's paragraph 83 of the second judgment. That was on the basis that absent the amendment, the petitioner would be struck out in accordance with his first judgment. He says, you'll see, the amendments sought are not trivial, nor do they simply fill in lacunae in a previously pleaded case. They are substantial and plead a serious case which had not previously been raised. If they are to be amended in this substantial way, it's only fair that the respondent should be entitled to plead to in full. I don't know whether your lordships have been taken to the amendments that were made to the G&G.
We've seen them.
They are substantial. It's not simply a question of adding in a his or there or something. They are substantial new points. And the order the judge made was imposing a condition as per the Rule 3 provision, which I took your lordship to. Now, the reason why he imposed this condition, we say, was to deal with the case justly and at proportionate cost, and to ensure the parties were on an equal footing, which is one of the bases on which the overriding objective should be pursued. We say the imposition of a condition was an entirely proportionate and effective means of achieving the purpose of conducting the case fairly and justly. And we say, indeed, there's no other result which a judge could properly have reached, because Neil and Charles were facing an entirely new claim. Of our perspective, as the judge saw it, the claim had been, not only had the claim for relief against Neil and Charles been struck out, but the petition itself had been struck out. And I can take you to a launch of the order to show that that's what he'd ordered. He'd ordered that the petition be struck out, but for subject to the amendment application. Perhaps it would be worthwhile to show you the order. So again, in bundle 1. Divider 6. So page 120 of the first file. The G&G strikeout application is granted, so that subject to the G&G amendment application, the reference to Neil and Charles in the prayers be struck out, and the petition be struck out. He then said, paragraph 8, the permission to amend sought by the G&G amendment application is granted, conditional on Neil and Charles being given permission to plead full defences to the points of claim. And just for completeness, you'll see that page 119 says, upon Mr Griffith electing, by way of a letter, to make the amendment referred to paragraph 8 below.
Why is 2.1 there? Why is 2A there? If the petition's struck out,
Yes.
what does 2A add to it?
It may not add anything, but the judge ordered the petition to be struck out. It may be the 2B renders 2A unnecessary. It's just procedurally, we're talking about a situation where it wasn't just a question of the claim proceeding against someone else, and so there is an extant claim. There was no extant claim. Subject to the application, it was struck out, and there was no claim. So we say in that context.
I mean, what was the position? Right, so there was nobody else involved in this.
No remedy was sought against Mr Gourgey Senior or anyone else.
Mr Hodges, joint trustees of the estate of Robert Hodge?
He was a respondent, but no relief was sought against him.
No relief was sought against him.
And you'll see from that that the hearing, the first hearing that led to the first judgment, proceeded on a basis, but there was no application to amend. Mr Griffith's position was there was nothing to complain about. But it was a new claim now because the first judgment having been handed down, the petition was dead.
I'm not sure about, just to get the dates right, because I see that the amendment application, oh sorry, that's the Bankside one, isn't it? G&G amendment application. Oh, I see, not till the 13th of July, yes, sorry.
Yeah. So it was 2 months after.
Yes, I see. So the first judgment was given at a time when there wasn't an amendment application.
Yes.
Yes.
So there was no extant petition.
Well, that's not quite right, because the order, because no substantive order was made following hand down of the first judgment. The order is that which you've just shown us, tab 6, and that said that it's struck out subject to the amendment application. And indeed that's what's happened. So the existing proceedings, the existing petition and the existing points of claim have been amended.
They have been, yes.
There's no question of the proceedings having been struck out.
So they were.
It's not a new claim in the way you've described it.
Well, perhaps I expressed it inelegantly. It was a claim which, but for the amendment,
Sure. Sure.
was struck out.
And that's the point the judge makes in the paragraph you took us to.
Yes.
And just for completeness, there's the earlier order at paragraph tab 5, and this is in draft. Was that perfected, or is it at any rate accepted that that's the order that was made following the first hearing?
From memory, that seems familiar.
Yeah. So that was probably agreed between the parties, but not ultimately stamped or whatever.
Anyway, so that's the short point.
The point is we're not talking about a situation where but
The short point is it would have been, if the short was up for the amendment, it would have been struck out.
yes.
All of these, for the you would say, for the first time, raised a substantive case which didn't previously exist against Charles and Neil. There were no other respondents who were involved in this, so effectively it was a new claim, and effectively, well, the same petition. It was a completely re and it was within the judge's discretion.
Yes.
That's the short point.
That's the small point. Yes, my lord. And I say there's no exercise for the court here to disturb this exercise of the judge's case management powers. We've made submissions as to why the Michael case is not on all fours with this case. I don't know if that's useful for me to explain it further.
We haven't heard any. There's been no reference to the case.
Well, if I won't.
If the case is referred to, we'll allow you to respond to it.
I'm grateful for that.
So far, we haven't had a reference to the case.
So those are the simple points. So this is
On G and G.
on G and G.
So do you want to just deal then with the last ground of appeal?
Yes, which is the 8 shares point.
Each share.
Now, that was dealt with at page 82 of a judge. Or maybe it should be 182 again. Paragraph 60, yes, 182 of bundle 1. Paragraph 60. I'd like the court just to read paragraph 60. Now, the point made at paragraph 60 picks up a point which had been made earlier at paragraph 42 of the second judgment, which was in respect of true show, where the issue is whether if there's amendment made to plead a case against true show, where would that leave everyone else pleading wise? And that was addressed at paragraph 42 of the judgment, page 178 and 179.
Sorry, I'm so sorry, which paragraph?
Paragraph 42.
42.
It's the same reasoning which the judge was engaged with. you'll note the concern about making for an unsatisfactory, if not incoherent, pleading if they're not allowed to plead in full, and also reference to the need to satisfy the court whether Section 996 jurisdiction is engaged.
Where are you reading from?
That's paragraph 42, right at the bottom of page 178. It would make for an unsatisfactory, if not incoherent, pleading if they were not allowed to plead in full. And then he says, the second reason is the court has to be satisfied as being unfairly prejudicial conduct. It can't be unfairly prejudicial conduct vis-à-vis one respondent but not another.
There's a general proposition that can't be true.
I say that because he's picking up the same point, or a similar point to paragraph 60 when he deals with
If the facts are identical in relation to each respondent, that's obviously true, but as a general proposition, you can obviously find that a series of respondents there's unfair prejudice against some and not others, depends on the facts.
You might find there's unfair prejudice, but the remedy should be granted against one person but not another. I think the point he was trying to make there. But the point on paragraph 60 he was making, specifically, we're talking here about the same respondent, Mr Gourgey, Senior, and the fact that in respect of the underlying allegations, the court would need to consider both. Consider the situation both in respect of the 8 shares and the 25 shares. Now, I submit that the concerns that the judge raised are entirely sensible case management considerations and consistent with the fact of concern of ensuring that parties are on an equal footing. The judge pointed out in paragraph 60 of his second judgment the instruction of the new paragraph 3b to plead for the 8 shares would be to expose Mr Gourgey to a more extended relief than that to which he exposed under the existing pleading. And so it is not just a question, as my learned friend says, of adding to the quantum of a claim. It's a new claim. It's a claim for a share purchase order in respect of these 8 shares. It's not, it is a new claim because it's a claim to a remedy in respect of these 8 shares.
But based on exactly the same claim or allegations as the claim for relief in respect of the 25 shares.
As pleaded, yes.
Yeah.
But Mr Gourgey should be entitled to run defences to the 8 shares claim as a new claim.
Why?
Because it's not simply a question of adding to a quantum. It's bringing a new claim to relief.
If he had 33 shares at the start rather than 25, the claim made in the petition on particulars of claim, points of claim, would be exactly the same, except in relation to the relief. You should buy out my 33 shares, not my 25, but there would be no other change apart from administrative changes to the number of shares held.
Well, there are, as we highlighted in our skeleton argument, specific points which arise in respect of the 8
Well, I
shares.
understand that, which is why we put to Mr Parker, do you accept that Mr Gourgey could rely on those matters and, if necessary, plead facts relevant to those specific points that he accepted Mr Gourgey could?
Yeah, that was, my lord, I say, a change of position on their part. The position until then was we could only plead to the fact of the, acknowledge the fact that they...
Whether that had been teased out in correspondence or otherwise with him, whether you had asked him, do you accept we can plead the matters we specify in our skeleton?
My lord, it was, their position
The
was...
answer is no, you haven't teased that.
Well, my lord, their position was very clear that you can't do anything...
Are you saying you're entitled to do more
than
plead those matters you refer to in your skeleton?
We say that, first of all, we say we're entitled to plead to any particular points that arise out of the 8 shares.
Yeah.
But that carries, as well as that, we say that this is a new claim, which your lordship heard my argument about that. But also, it's an unsatisfactory situation where you have a situation where the court has to decide, in all the circumstances of the case, what remedy to grant under Section 996. For a party to have a situation where it can partly plead to it in a limited way in respect of the 8 shares is, I submit, an unsatisfactory position to place that party in or the court in. We're talking here about a substantial sum of money. The petitioners have said that these 8 shares are worth at least £3 million. And we say that the judge was right to say, well, if you want to get the court's permission to amend, to bring in a claim in respect to these 8 shares, then it has to be on the terms which he provided for paragraph 60. If you look at it this way, it would have been possible for the petitioner to have presented a separate petition in respect of the 8 shares. And in that case, there would be no question.
Thoroughly abusive exercise. I mean, where you've got an existing petition on foot relating to 25 shares, and you make precisely the same claims of unfair prejudice in relation to the 8 shares, as it were, to present separate proceedings. I think would be struck out as an abuse to be told to make the existing petition.
My Lord, the point I'm making is simply that the petitioners, the respondent, Mr Gourgey Senior, will be entitled to plead in respect of 8 shares, not simply to the fact they are held now by Mr Griffith, but a number of matters going to the question of whether any remedy should be granted to him in respect of those 8 shares. He accepts that. Now, once that's opened up, then the question is, well, how do you, to what point do you draw the line and say, well, the respondent can partly plead to this. The court, when deciding in all the circumstances of the case whether the petition is well founded and if so, what remedy to grant, has a partial response on certain matters. Will it say, well, you've pleaded to the 8 shares, you can plead in respect of up to this point about the unfairly prejudicial conduct? For example, one of the points we raised was that Mr Hodge is the person, his trustee is the person from whom the shares were acquired. And we're saying that if Mr Hodge acquiesced in the breaches, in the alleged unfair prejudice, the petitioner who derived title from Mr Hodge cannot, in respect to the 8 shares, cannot obtain a remedy in respect to his 8 shares when at the time when the alleged unfair prejudice took place, Mr Hodge was the shareholder in respect to his 8 shares. Now, so we would be wanting to plead to the fact that the matters relied on were acquiesced in by Mr Hodge, which would involve an examination of what actually went on and who consented to or acquiesced in what went on. The position is...
You would be saying, let me get this right, you would be saying, wouldn't you, that Mr Hodge had consented to the unfairly prejudicial conduct. So the unfairly prejudicial conduct is on this basis a given. Mr Hodge consented to it, so you would be, maybe that's legal, I don't know. And therefore, that affects the relief that Mr Griffith can get as regards the 8 shares. I can't at the moment see any obvious problem with that.
Well, my Lord, the devil may be in the detail once we if the position does lead to pleadings. But what we say is that the judge made a case management decision, paragraph 60 of his judgment. The court would have to decide that this court will have to decide that what he decided was beyond the ambit of the reasonable discretion he was given. He carefully considered it in a reserved judgment, having heard argument. This was his second judgment, so he had heard argument over a number of days, both leading to the first judgment and the second judgment. He had a very clear idea of what had happened historically, procedurally, and in terms of pleadings. And in my submission, one has to point to bearing in mind that we're talking about a jurisprudence, a power derived from the CPR. One would have to say that he exercises discretion on a wrong basis, taking account of inappropriate matters. We submit that test is not satisfied here.
I'm just saying the same thing, probably in different words, but it would mean, wouldn't it, that here the addition of the extra shares set at naught the striking out of your defence by ultimately Mr Justice Simon, upheld by the Court of Appeal, you'd be back in 2013, and indeed you could rely on effectively just the same document that you put in then and had struck out for failure to comply with orders for the provision of further information.
What happened is, in circumstances where he had a petition afoot, Mr Griffith elected to buy these shares.
But just on the, I'm right, aren't
Yeah.
I?
You're right.
Yes.
You're right. Yes, my lord. But the backdrop is that he elected to buy the shares. He didn't then amend to plead that before the strikeout order took effect. He bought the shares at a low price. He now wants them to be bought out at a very high price. I think.
These are all arguments to go to whether he should get the relief he seeks in respect of the 8 shares, aren't they? I mean, the sort of points you're outlining now would be matters to the trial judge.
But it's also a question of him having elected to go down this course. He didn't have to. He could have decided, I want to keep with my procedural advantage, and I'll stick with the 25 shares.
So you're saying he's elected in such a way that he can't have the 8 shares?
Well, if he wants to bring in a claim in respect of the 8 shares,
Yes.
then he has to accept the consequence of
You
the.
couldn't fully plead.
He could on
That's
receipt.
what we've just
Yes,
heard the argument about.
on receipt of his judgment, he could have decided,
Yes.
I'm going to elect not to amend, and so I'll keep it to 25 shares.
He's appealed then.
He-
Well, you're not advancing an election argument, that he's prevented from running this appeal.
No. What I'm saying is that he had a choice when he received the judgment. Do I go ahead to obviously subject to this appeal? And assuming for present purposes his appeal is dismissed on this issue.
Decide not to add.
He could say, well, I don't.
Decide not to add the extra.
I don't want to catch you at the extra 8 shares because
Well, that's obviously true.
Yeah.
No, that's fine. So now, have you now completed all your submissions on all 5 grounds?
subject to any way I can assist the court. Yes, my lord.
Very much indeed. Yes, Mr.
Well, I'll have 6 short points to which arise out of what Lord Justice David Rich has asked me. First, the summary of the relevant complaints in Mr Justice Simon's judgment, paragraph 5 to 13. We also agree with that being a useful summary, subject to the fact it doesn't make mention of the complaint in paragraph 36, but a useful summary. Secondly, the strikeout application, the previous one, some dates, my lord, that was launched on, it was issued on the 14th of June 2013, so that's after the points of claim.
So which of June, sorry?
On the 14th of June 2013.
Not proceeded with, is that right?
It was, it was pulled, a hearing was scheduled on the 27th of February 2014, and they withdrew it shortly before. And as I say, it was to strike out various paragraphs that relied upon conduct with respect to other companies. And we have the paperwork, but I'm not sure Your Lordships will won't be burdened with it. And the first of my points is a reference to the transcript of the hearing before Sir Nicholas Warren on the 20th of April, i.e. the first hearing, because at that hearing, as the transcript shows, it's internal page 42, and again, I've got copies if Your Lordships want them.
Which volume?
It's not in the bundles, I'm afraid.
Internal there, I see.
Yeah, sorry, it's internal. To anyone wants to check it, it's where I accept that the plea in paragraph 36 and the allegation of director's duties in paragraph 19 needs to go into the petition. I say, but my lord, we would accept that the plea in paragraph 36 and obviously the allegation of director's duties in paragraph 19 need to go in the petition. And Sir Nicholas says, so you would seek to amend. I respond, seek to amend the petition. And that's when Sir Nicholas Warren goes
20th of April 2018.
Yes, Lord.
And which day is that of the hearing?
That's the Friday.
So that was what, day 5? When did it start? Is it your opening?
No, my lord, we'd had the extensive debate about the true show
I think the
case first of
hearing
all.
dates were the 19th to the 23rd of April.
Yes, this is the second date.
So this is
Second day. Yes, second day, yes.
right, yes.
Then my third point is to. So my second point is to point out that when our friends said at the opening of the submissions, they read the petition as alleging that they were nominees. And in my submission,
I think he said actually they read ground one of your grounds of appeal as alleging nominee. That's what I understood Mr. Lackman to say.
well, my lord, I respectfully beg to differ, but to your lordship, as your lordship's recollection, I'm never going to disabuse you of your lordship's recollection. So I'll move on. My next
So
point
I've
is.
actually got, we read ground one as a plea of nomination.
I'm sure you're right, my lord. I apologise for my misremembering. 31.2, points of defence. Master Rolls was pointing out, well, that goes to the position of shareholder. It also overlaps with the position of director, and on that I refer your lordships to paragraph 80 of the second judgment on page 192.
Then the judge picks up the subject of the point really there, which is that the actual pleading is an agreement by not Neil and Charles at all, but by the three principal players, Mr Gourgey and the other two, and that what's alleged there in effect, I think we derived this from our exchange earlier on, it's an allegation of agency. That's how you address that point.
Well, my lord, certainly.
I'm not sure the judge has fully explored the subtlety of the issues there.
Your lordship sees, he goes on to say, I consider that the sanctioning by 100% of shareholders of conduct which would otherwise by breach of duty of the director is participation in the affairs of the company, and your lordships have my submission that we had attempted to allege a relationship between the sons and the father in respect of the shares, and we had had this specific response as to what that relationship was in 31.2. And we say, fundamentally, is it seriously suggested that on this particular point, that our pleading would fail because we haven't been to court and said, can we have 31.2 specifically referred to in our petition? Does one have to have a rolling programme with respect to one's particulars of claim every time there's a useful averment in the defence to say, well, we now need to plead that and put it in our particulars? Because otherwise it'll be said, you can't rely on it because it's in the defence. And we say that's not a sensible, proportionate way to view statements of case. One looks at statements of case as a whole.
Sorry, who's saying you can't rely upon it because it's in the defence?
Well, my lord, I simply make... Sir Nicholas Warren effectively said that because we hadn't pleaded it. We hadn't pleaded 31.2 of the defence in our initial points of claim, in our initial petition. And we say, well, we don't need to. We had made an allegation, ambiguous, poorly, unclear, as to there being a relationship between the sons and the father in respect of the son's ownership of the shares. Akin to a nomineeship, and the response he doesn't like to take issue with anything we say about the interest of the sons being treated as the interest of Mr Gourgey, and the defence pleads the same. But then they go on to make a specific representation about that relationship by saying that Mr Gourgey is their representative. And we say, as does Sir Nicholas Warren in paragraph 80, that that gets us home. And it shouldn't be said against us, but it doesn't get you home because you haven't referred to it, you haven't amended to refer to it.
I don't know. I think they're sort of all over the place. I'm not quite sure which point you're directing or what point to.
That's ground of appeal 1, my lord.
No, I know that, but I thought you'd accepted that there'd have to be an amendment to the petition in any event.
I do, because of the ground of, to get my ground of appeal 2.
Yes.
But this is not so, I mean, this would be amending the petition maybe, but more importantly, paragraph 31(2) is in the defence, and you say it should be read as if it's in the particulars of claim and in the petition.
My lord, yes. And my final point, my final point is with respect to the conditions.
So can I just pick you up on that?
Sorry.
Well, you say you have to, because it's in the defence, you have to read it as though it's in the petition and the particulars of claim. But I thought you accepted, in relation, for example, to paragraph 36 of the defence, that those matters did have to be pleaded in the petition, and that's why it had to be amended.
I think there's a confusion. Yeah, 36 is in the points of claim.
It's points of claim. The fiduciary duty.
Yeah, that's in the points of claim, and
Oh,
you say,
But that's not in the defence.
no. It's,
The defence responds to it, but
yeah.
the origin of the facts is the points of claim which they then respond to. The origin of the specific fact of Mr Gourgey being their representative is in the defence, because that specific fact was not pleaded in the petition. But we say it's consistent with the fact that we have raised the question of the relationship between the father and the sons in respect of the shares through the allegation what we might say to be akin to nomination. It's not a situation where we've pleaded the bond contract.
I still find this confusing, but I have to answer this point then. You say that you accept you have to amend the petition because paragraph 36 is in the paragraph 6 is in 19 and 36 is in the points of claim, but not in the petition. It's accepted that paragraph 31.2 is not in the points of claim, but is in the defence. But you say that doesn't matter because that can be read as in the petition, and isn't there an inconsistency there?
No, well, because we have made a general allegation in the petition about the relationship of the father with the sons in respect of the shares being in the registered ownership of the sons. We've said those shares are to be treated as Mr Gourgey's shares. They have come back in their defence and pleaded in similar terms. I'm sorry, Lord?
You said that in the petition.
We do say that.
So
We said that in the
treated
petition.
as his shares.
Yes, the parties. We refer to the party shareholdings. Profits were to be
Back to that point.
That's the point that I began with this morning. It's not. I think possibly it wasn't totally well received. But my point is that within that rubric, within that general rubric of what's the relationship and what's the petition trying to say, we have their response as to what the relationship is in respect of the shares, because the sons say Mr Gourgey is our representative and has ratified his conduct.
So at this point, all turns on the point you say the petition makes clear that your claim is that he's their nominee. So they're his nominees.
Yes.
It all turns on that.
Well, it all turns.
It's very vague other than
I'm not saying put forward any sort of principle here. I'm just saying the circumstance of this case. The
I understand that,
relationship.
but I'm trying to understand the point.
Well,
I appreciate the point derives from your saying that the petition makes clear that their shares are to be treated as his. You're saying
Yes.
the petition makes that clear.
Yes, well, and that's how they respond. And then we have the added fact of the specific allegation.
added fact. But if you postulated that your petition and your points of claim on this point didn't provide a sustainable case, assume that against you. You can't make it good by pointing to something in the defence
can, my lord, because what I'm getting at is if you bring a claim about one thing and then you have a defence about something else, separate, that would give you a claim, you can't say, okay, well, my claim fails, but I've got a different thing.
That's what I'm putting to.
Yes, but in the context of this petition, we are alleging there has been unfairly prejudiced conduct by Mr Gourgey in circumstances where the 50% shareholding is as good as his.
Yeah, but I'm saying that assuming for the moment against that the way you plead it in the petition and the points of claim, it does not set out a sustainable case for relief against the sums on this point. In those circumstances, it would seem to me it would be difficult for you, which is probably code for saying impossible, for you to seek to make good your case by reference to something in the defence.
If your lordship say, well, if your lordship's saying, well, that's just a hopeless legal concept, then I agree. But if your lordship's saying, well, we're not quite sure what you're getting at.
So
But you can then read
make
that,
your case for it.
well, this is the point that thorough charging in Rawdon says. You can
that's the
understand.
point. You rely on fever rapture for this.
Yes, you can understand what we're getting at by reference to their treatment of it in the defence.
Just in terms of what you say you want to amend, you want to amend the petition in respect to paragraphs 19 and 36, and that's it.
My lord, yes.
Yeah.
Because on the ground one of the appeal point,
Yes.
we say, well, whatever the failings in terms of a lack of precision in what we said in the petition, it's sufficient for us to be able to rely on 31.2 of the defence. So my final point is in the context of Sir Nicholas imposing this condition. I'm not going to revisit the 8 shares point, but in terms of his response, if we needed to amend the G&G petition beyond simply introducing paragraphs 19 and 36, we say that his lordship's exercise of the discretion, one can almost say, clearly proceeds on a false basis by reference to what he did with respect to the 8 shares. But aside from that, there's no consideration of the point that is made in Mitchell and Phillips, which is that the respondent is being treated as being in a better position than somebody that has an extant defence. If we were amending in circumstances where the points of defence were still in existence, they would have permission to make consequential amendments. They couldn't just rip up the defence and start again. Whereas here, they're being put in a better position than a party whose defence has not been struck at. And that's the point that is made by Mr Justice Sewell in the Mitchell and Phillips case, which you have the reference to in
Mitchell.
Mr Justice Sewell. And Mitchell and Phillips.
Michael, actually.
Yes, sorry.
It's actually Michael and Phillips.
Michael.
Yes.
Michael and Phillips. Sorry, I was saying Mitchell, I do apologise. And your lordships have that if you want to look at it in the second of the authorities bundle at tab 25, and the relevant paragraph is paragraph 8. So we say that the discretion is not exercised on a proper basis and is out with the discretion. So thank you.
we're extremely grateful to both council for dealing with this matter as efficiently as I hoped it would be dealt with. I'm extremely grateful to both of you. We will consider our judgments in this matter in the usual way. When you receive the draft judgments, please deal just with textual and grammatical errors only, not to rerun the case, and please agree a form of order. Any further submissions are to be in writing unless we say otherwise. Thank you both very much.
The only query I had is that Michael and Phillips was raised by my learned friend. We specifically said if I don't know if it's important for your lordships to consider that case. I'm happy to we do refer to it in our skeleton argument from paragraphs 31 to 35,
Yes.
pages 80 to 82. To the extent that my learned friend seemed to place some reliance on it, I had some submissions to make. I don't want to take
In
up any
addition
more
to
time.
those there, would it be sufficient for us to read those submissions in there?
I think it would be sufficient, but to get my learned friends trying to rely upon it heavily, we say it's a very different situation from here. In that case,
We've got about 3 or 4 pages.
we got one debate, so I just wanted to draw to your lordship's attention
Very
about
different
that.
situation.
And it was where it was the amendments were brought about because of non-disclosure or late disclosure by the.
You've made that point in your skeleton.
Yes, I just want to draw that to your attention. That's all. I'm sorry to take up any more time.
Well, I don't want you to feel you haven't had a fair crack at the mill. So we'll certainly read paragraphs 31 to 35 and take on board your point. It was a very different situation that the amendments are brought about by non-disclosure.
By the party who'd had their defence struck out, and in that case they were debarred from defending.